So as you know that President Ramaphosa has gone to the Western Cape High Court to block the impeachment process from going forward. So the lawyers for the EFF, for the impeachment committee, for the MK hammered him as Trengove was a lone figure defending the president. In this video, I'm going to show you the greatest highlights from this long court case. And if you stay with me all the way till my biblical reaction, I think you're going to get a little bit of comfort from what I say at the end, because South Africa will prosper. You ready? Okay, press like, let's go. So, of course, they're asking for an urgent interdict to stop the committee that has already started from starting. Well, the first thing the judge asks is, but what if we stop it and then you lose and then you appeal?
Interdict is sought only, and I quote, pending the determination by this court of the application for review. Now, and that hearing by this court has been set down for 2 to 4 September. So this interdict will run only when this court gives judgment on the debate which is to be had in early September. One imagines it would be sometime in September. So that's a very limited duration of a stay that the president seeks.
Well, that might be the argument by the president, but we know in practice what can happen is that if the review court does not find in favor of the president might appeal.
Yes, indeed.
And then that might stay the further proceedings.
With respect, not. This court's order will expire when this court gives judgment in the review. What happens beyond that will be for that court to decide. My client hopes that he's going to win and will not require any further proceedings. But it's not an issue for you to decide today.
Well, Trengove is really fighting a tough case on this one. But the point that he made that I find most interesting is that he says his client is basically saying, I bruise easily, so be gentle when you handle me.
So are you suggesting that the report is in fact the trigger for the impeachment committee to be established?
It's a trigger for the process which the court has held to be punitive. And that is also the president's own objection. He says it's humiliating. It is insulting for me to be the subject of a public hearing of impeachment. And the rules entitle me to the protection of a lawful independent panel report. So I'm entitled to test the lawfulness of the report, and if it is not lawful, then I'm entitled to an interdict of the next step.
The president finds it humiliating and insulting to take questions from Parliament? So the next lawyer comes up and the judge wants to know.
So if the speaker hands over the report to the impeachment committee, whoever feels aggrieved by the report, according to your submission, cannot now come for a review of that report because the impeachment has already got it.
No, I'm not saying that. Because the speaker, rather than the speaker is just one of the functionaries in the scheme of things whose decisions or actions are susceptible to review. So there I'm not saying that. I'm saying that in a situation where the report has already been the subject of a court order and the court itself, not the speaker, has referred it to the impeachment committee. So these are two distinct situations. So first, you have a situation where the report has not been subjected to the scrutiny of the court. The speaker is referring it to the impeachment committee. That is a decision of a functionary which is susceptible to review. It can be, whether under legality or whatever. That you can do. So here I'm saying that the president has missed the boat. That's the point that I'm saying. He has missed the boat because this report was in front of the Constitutional Court to be scrutinized and looked at by the Constitutional Court. The Constitutional Court, rightly or wrongly, made an order. Section 165.5 is very clear. Whether then you are happy or unhappy with the order, it remains an order.
Okay. Then he gets hot under the collar and pretty much says, listen, the president is messing us about. This must end.
We live in a constitutional democracy where we must respect the rule of law and the court orders. And the president himself is one of those people who actually is a first citizen, must be the one who must lead by example. He's the one who must be able to say that I'm going to ensure that this order of the Constitutional Court, which is the highest court in the land, is respected, and I'm going to support, like organs of state must support and must ensure that they protect the dignity of the courts. He will say that I am actually leading by example by making sure that I'm going to support the work of the impeachment committee established by the Speaker, and I'm going to avail myself whenever they need
I've
me
got no
in order
difficulty
to place this into
with your
rest.
argument. That's my only difficulty that I've got.
But my lord,
May I ask you a question, Mr. Mokhare? It seems to me your argument is predicated on the idea that the Constitutional Court has closed the door on challenging this report. And you say that because you say paragraph 7 of the order says it must go to the impeachment committee. But are we not to interpret the orders of the court in the light of the judgment as a whole and in the light of the questions which served before the court? It didn't ask the question that the review court is going to have to answer. Not so.
No, you're absolutely correct, Justice Davis.
And if it didn't ask itself that question, and if that was not what it was grappling with, surely it can't have definitively pronounced on it. That's what the review court is going to have to do.
Well, you're correct on the first part, then Justice Davis, that that issue was not before the Constitutional Court. It didn't have to pronounce on it because it was not before it. It can't pronounce on that. But what we have to look at is the order itself read together with the reasons for the judgment. So the finding, if that was such a finding, one would have gotten it then in the orders themselves because it's an important one. So that the court can explain how did it refer a report that is still susceptible to review or may be susceptible to review to the impeachment committee. But let's put it then differently and say that. Let's say then we accept the proposition that indeed, because the Constitutional Court has said in paragraph 139 that a report of the independent panel may be taken on review and therefore the President has done so. You still have to read that together with paragraph 7, which means that as the impeachment committee, we have to comply with the order of the Constitutional Court by making sure that we proceed with our work. And the President can continue then to review the report, and whatever outcome comes there is never going to change the fact that the Constitutional Court has said that the impeachment committee must do its work, and its work is that it must investigate and submit a report to the Speaker for a voting, so that that entire process, which started with the notice of motion submitted by the member of Parliament, is now brought to conclusion with a vote. So that will still happen because the court order must still be complied with. Otherwise, it will be to make a mockery of the state decisions principle that you have a higher court which then is going to interpret the Constitutional Court orders in a manner that undermines the very orders that the Constitutional Court has granted in order to give finality to an important matter such as this, especially taking into account section 237 of the Constitution. Constitutional obligations must be performed immediately without undue delay. So how does it help the Republic of South Africa that a motion that was initiated by a member in terms of section 89 of the Constitution is halted through judicial process, despite that constitutional obligation is to be performed to finality, and the President is never held to account at any stage, given that a President is not somebody employed indefinitely or for life, is somebody then who is elected for a specific duration of 5 years. Those are the factors that the Constitutional Court has taken into account to come with such an extraordinary order. I accept it's an extraordinary order, actually. It's quite extraordinary. And I want this bench to ask itself that question. Why did the Constitutional Court make this extraordinary order in paragraph 7 of the order? Because it has concluded that this report must be processed as a matter of great importance, and then you've seen in the preamble, paragraph 1 of the judgment of the Chief Justice, this is a matter of grave public importance. But then when we are now engaging on litigation which seeks to undermine that very order, then we are really what message are we sending to the nation? That court orders can simply be disobeyed, or we can come with some kind of innovations and technical legal niceties not to give effect to them. But these are not only our orders, these are the orders of the nation, of ordinary people who are sitting there, who want to see that this constitution is alive and it can actually take us forward, not backward. So I'm saying that as a committee, we are going not outside what the Constitutional Court has said. We are keeping ourselves within what the Constitutional Court has said to us, and that you have a report in front of you, process it, and then the President says that High Court interdicted them, they mustn't process it. I don't know then what the court is going to do, especially in the light of the jurisdiction point that we've raised, because, well, there is already the Zuma judgment in the KZN. So either this court then must differ with it or not, but there is a precedence on that issue that you can't interdict.
What relevance is that Zuma judgment to this matter?
Well, I think the message, I think the essence of it is simply to say that when there is an order which already compels or requires you to do something, that order can only be stayed or maybe rescinded by that very same court. So we say that it's a Constitutional Court order. If the President wants to stay it because it's prejudicial to him, he must go to the Constitutional Court. And that's the court that will be able to entertain him because it has the power to do so.
In that matter, it was the Constitutional Court that made the order.
It was the Constitutional Court that made the order.
Not the case, Constitutional Court, as I understand it, didn't rule on the report per se. It dealt with some other issue.
What I'm saying is that the President wants to stay paragraph 7 of the Constitutional Order. He doesn't say so in the notice of motion, he doesn't have to say so in the notice of motion. That is the effect of it. I'm talking about the effect. So I'm saying that it is an order of the Constitutional Court which the President wants to stay. Because this inquiry, it was never going to be established if it was not for this judgment. We were never going to be sitting here and dealing with this issue. Because as Mr. Trengove said in his of arguments that it was 3.5 years ago, we were never going to be. Actually, the President's term was going to come and go, and was going to leave without anything. But this is a trigger. The Constitutional Court then has actually brought us now back to our constitutional duties to say that Parliament, you have a constitutional obligation to hold your own President to account. And you must do so and do so immediately. And that's what they're saying to us.
You've got 2 minutes, Mr. Mokhare.
But then Advocate Katz SC says, man, this is a movie.
I said to my junior, Mr. Purumulsami, I feel like I'm in a movie. Because this
looking at all these cameras, it looks like it.
Yes, but the movie, well, let me talk about the name of the movie. The name of the movie is Nkandla to Palapala, the saga continues. And 4 of us, that's Mokhare, Mpofu, Trengove and I, are veterans of this saga. And this is what happened. The Chief Justice in Nkandla says to this court what this court should do. And may I read it? It falls outside the parameters of judicial authority, that's this court, to prescribe to the National Assembly, and we emphasize, how to scrutinize executive action, what mechanisms to establish, and which mandate to give it for the purpose of holding the executive accountable and fulfilling its oversight role of the executive or organs of state in general. The mechanics of how to go about fulfilling those constitutional obligations is a discretionary matter best left to the National Assembly. The court should not interfere in the processes, and we emphasize processes This is a process disturbance. And I'm not talking about the review. I'm talking about what's going on today. They're trying to stop a process.
But it's part of the review.
No,
it's part of the review.
I'll come to that, my lord. I'll come to that. But it's not. This is not the review. This is a disturbance of a process that is unfolding. Because if you're right, my lord, then you might as well do the review today. There's no review before this court today. There is a process disturbance, interference with a process. That's what is in the lane and the realm of Parliament. And this court should be on high alert not to cut into that lane.
But if you with regard to the factual matrix of this case, here, as Mr. Mokhare has pointed out, the Constitutional Court referred the report to the committee. Now, how can the President complain about that? There was no discretionary powers given to the Speaker.
No. So
The court said, here's the report, it goes to the committee. That's the point that they made. So there was no discretionary powers that the President can complain about.
I'll make a different point, Justice. When the President brought his review,
yes,
he then wrote, I think he wrote to the Speaker, and he said to the Speaker, please hold off on continuing. And he wrote to the Impeachment Committee saying, hold off on continuing until the review's finalised. Your Lordship will recall that on paper.
Yes.
And what did the Speaker and the Impeachment Committee decide? I think together or in some way or other. They looked and they said, we've looked at your review. We have a constitutional obligation to do what we've got to do under 237 of the Constitution in a particular way. We are continuing. He then brings his intellect. So when your Lordship points to paragraph 7 of the Constitutional Court judgment, it's got nothing to do with the point that I'm now making, with respect. It's a different point. Parliament could have said to the Speaker, could have said to the President, oh, we've looked at your review. We hear that you've got a review coming up in September. We'll stop. Or we'll continue our preparatory work. We won't call witnesses. We won't call you. They could have said that, but they chose not to. And when they made that choice, that's their process. It was for them to decide, and there's no suggestion that that decision was in any way unlawful or unconstitutional. That's the point. They had a discretion. They could have stopped, but they chose not to stop. They chose not to hold the thing in abeyance. That was their decision. It was their lane. And they made that decision, and there's no suggestion by anybody ever, not by the President, not by his counsel in argument, that that decision was a bad decision. But this court will, in the circumstances, not interfere with that decision.
And just in case they missed the point, Katz tells them straight, stay in your lane.
She has availed herself to be chosen to occupy this position. Mr. Ramaphosa availed himself to be chosen to be the President. And with this high position goes the requirement to subject herself, in this case it's himself, to a lawful and constitutional process. This, in our view, cannot possibly be seen as harm, let alone irreparable harm. It also must be so that the granting of the interdict will cause irreparable harm to that doctrine of the separation of powers. It was my second foundation this morning. That if you grant the interdict, there's a suggestion that there's no harm to us. It's a few months. Us being the people of South Africa, separation of powers, that's the harm. It's rule of law harm. That if you grant the interdict, there's huge harm to separation of powers. Don't, we suggest, cross your lane, justices.
Well, we don't want to do it. Well, it's not our intention to do it.
No, but
we will stay in our lane.
Well, we would suggest, my lord, if you stay in your lane, you wouldn't grant the interdict. But if you do grant the interdict, you'd be cutting into the lane of Parliament. How they've chosen to deal with this impeachment process, how they've chosen to deal with the President's request for a stay, that's their business. I emphasize how.
And then the next lawyer for the EFF says, ain't nothing special about the President that he's embarrassed or humiliated or insulted by talking to Parliament. I mean, how embarrassed do we get when we get taken to court?
What the president purports to be his refuge to safeguard against that is to, on technical points, have the report set aside rather than answer the question of the veracity of the claims. The veracity of the claims can only be dealt with at the impeachment committee, where it's got an opportunity to put forward evidence that disturbs the conclusions that were found or made by the panel itself, and that would truly remedy his concern, which is of reputational harm. It is him showing his innocence of the charges that will truly exonerate him. It is not a technical argument.
But doesn't that put an onus onto the president, that he must prove his innocence?
Well, perhaps it is even unfair to suggest he must prove his innocence, because all he is a witness before the impeachment committee. But the point is, if ultimately he wants to disturb the findings that there's prima facie evidence, sufficient evidence rather, that shows prima facie case, if he wants to disturb that finding, he must provide the evidence. And to the extent he can provide such evidence that disturbs those factual claims, then true exoneration, as we understand it from the president's perspective, would come about, rather than...
But the president says he's already given a version of events, and that's it.
Well, he hasn't been examined on it. The veracity goes slightly... There's a process that is far beyond what the panel had done. And we, of course, know the limitations the panel has, but I think more importantly, as with every matter of evidence, for it to be truly tested, it must be tested on examination, and contravening evidence may be led. It is only then you can get to a conclusion as to whether there is merit to the president's defense. After all, it is at the impeachment committee that the veracity needs to be made, and that is after examination, and that cannot happen except for...
But will that not
committee.
raise harm towards the president if, for instance, they use a report which ultimately going to be found whether unlawful or not? Now the impeachment committee gets their teeth into the president and put him on the spot by being cross-examined on something that, if it was not there, they couldn't have done the cross-examination on it.
Yeah, absolutely, my lordship. But
is there not a harm in you?
I accept there is. But what I'm saying is, what's exceptional about that? It's in the ordinary course where people are subjected to reports that are against them, then they are tested, and if they come right, they're exonerated. I mean, not to stretch the argument, it's common in criminal matters where you're accused of conduct. You put your version and you're exonerated in due course. There's nothing exceptional with the president, with due respect. There is nothing that's being asked of the president that is not asked of anyone else who's a member of society. So there's absolutely nothing exceptional. Neither has there been a suggestion that there's something exceptional. That is, the state president is of no moment for purposes of the argument I make.
And what was amazing was seeing Dali Mpofu on the right side of logic. It's like a different guy. But he answered the humiliation question. And his legal argument was, what?
Irreparable harm. Where is the harm? The only harm you can talk about, with the greatest respect, is the harm that has been pleaded. What does the president say? He comes here and he says, well, I cannot be put through the humiliation of accountability. What happened to the people of South Africa? We're all worried about the humiliation and all these things about the president. What happened to the people of South Africa? The people of South Africa can only hold the president accountable through their elected representatives, which is parliament. That's the only tool in the hands of the people of this country to get the answers of what happened in Palapal. It's the only tool. Who's going to talk about the damage to them?
But what damage can there be to the public in general speaking if money gets missing, your own money gets missing, gets stolen? What damage is it to the general public?
Yes, no, thank you, Justice Lekhat.
I mean, that's not for us to decide now, but I'm just throwing it out there for you.
You've asked the question, so the answer is going to come.
I mean, the people steal his own money. I mean, so what? What's the damage to the rest of South Africa about that?
No. Let me just answer that very briefly. I'll answer it with a rhetorical question first. Is it more pressing for the people of South Africa, as this court held in 2 cases, to know whether their public protector is incompetent than to know whether their president is involved in criminality? Is the kind of disdain we have for the people of this country that we say they do not deserve to have answers, yes or no? Because the answer we don't know, might be yes or no. But they don't deserve an answer, yes or no, whether their president is involved in criminality, whether he's involved in the torture of domestic workers, or the hounding of people in Namibia because they've left with these dollars. Or what happened to General Mfazi, who was murdered around this whole thing, and who's mentioned in the report as the most senior policeman who received this information. Can we really say that?
And just in case the judge doesn't know how to answer this rhetorical question, Mpofu skillfully introduces a new concept into court. It's called the taxi rank test.
Please, I implore this court to look into both the judgment of Justice Saldanha and Justice Erasmus. And it's 100% correct, unless this court, for some reason, finds that those judgments on the question of accountability and how crucial it is were wrong, clearly wrong, then this court is bound by its own decision. Let alone what I'm going to show you now, that you are also bound by the Constitutional Court. But you just, for starters, bound by your own decision.
Well, what do you make of the argument that was raised?
Sorry, Justice.
That's saying that those matters can be differentiated from this one.
Yeah. Well, I've already answered that question by that rhetorical question. How could it be that a public protector, the accountability of a public protector is more egregious than this case? It can be on anybody. You can go to the taxi rank and ask anyone, would you rather know whether your public protector is incompetent or whether the president had stashes of money and all the things that I've said? The answer will be the same.
And after saying everything, Dali Mpofu says, but anyway, forget everything I've said. I just have one thing to say.
This is where I should have started, because interesting as everything I've just said, it might come to nothing because the court has no jurisdiction, this court.
You've been speaking now for almost 45 minutes. You tell us now that we don't have jurisdiction in this matter.
I thought, Justice Francis, since we're here, let's just show how hopeless the case is. Now, let me, on a serious note, Justice Francis, this court, with the greatest respect to this court, cannot second guess, undermine, vary, amend, alter, whatever word you want to use, a judgment of the apex court. That I'm sure we agreed on, all of us. So that begs the following question. Is the order that is sought here consistent with the order of the Constitutional Court? If it is, then I'm wrong. But if the order that is sought here seeks in any way, small, tiny, minute, to alter what the Constitutional Court has said, then this court cannot do that.
And then he clarifies 2 simple words.
So they're saying, if the panel finds that there's sufficient evidence, then that report, as you said earlier, must be presumed to be valid unless and until it is set aside when in the future somewhere. So what does that mean? It means the words until and unless, and I've never looked at words like that for such a long time. Yeah. Until, according to the Oxford Dictionary, is about time. So until means, if this court says, I'm postponing this case, Mr. Mpofu, until the 1st of January 2027, I can't then come back and say I want it to be heard in November without altering that order. So if I want to vary the order, if I say I'm going to have anonymity and irreparable harm and what have you, I come back to the court and I say, court, I know you said we'll come back on the 1st of January 2027, but because for these reasons, can we do it earlier? Until that event happens, I am forced by reasons of section 165(5) of the Constitution to comply with the order.
So unless and until the independent panel is set aside, the independent panel stays, which means the impeachment can continue unless and until it's set aside. But the president is trying to interdict it before it reaches until. Pretty good argument. And finally, Dali Mpofu, the king of the Stalingrad, accuses Ramaphosa's lawyers of doing Stalingrad. Now listen, if Mpofu accuses you of Stalingrad, you are Stalingrading us. Case closed.
Paragraph 16 and 17 of that case says the following. The speaker had argued in that case, in the old days when the speaker was not abiding, when they were opposing the impeachment proceedings. The speaker said the process of impeachment carries 17 steps. And they were right, and then they outlined them. Mr. Breitenbach typically put them all there. And then, so what we're doing here is that if this court doesn't take seriously this argument in medias res, literally, and I'm exaggerating again, it means at every of those 17 steps we'll come here. No, complain about this, give us another interim order, then we deal with that one. Now 5 years later, we have another one. This is what Mr. Trengove calls Stalingrad. That's all that they're doing. They're just stalling and stalling and stalling and stalling.
And there comes the stay in your lane command again.
How can they succeed? They can't. With the greatest respect, this court, with the greatest respect, must return a decision that says, all this is all very, very interesting, but we choose to stay on our lane.
And so the next day, the president's lawyer had a right to reply, and he says, come on, guys, it's just 3 months. Come on. Just stop them for 3 months.
The humiliation that the president would suffer if this matter were to go ahead and the review was successful. Now, it's going to take a long time. There's a review which is set down in September. There might be further legal processes that continue. Parliament has its own agenda and so on and so forth. Now, Section 89, to hold the president accountable, that's really for the people of South Africa, okay? The general populace. So they must also be factored in to the issue of harm. Can something which happened how many years ago, how long is that going to continue for? And waiting for a time when there could be a definitive statement as to whether the president has done something or has not done something. It's keeping the populace, the electorate, in abeyance. So if I understood Mr. Mpofu yesterday, he says it's actually a parallel process. Continue your review, but also let the accountability mechanism continue on its part as well. If there is going to be humiliation and so on, that is just the part of the job, so to speak. When the president took on the position of president, he knew Section 89 was in place. Yeah, simple as that.
My Lord, let me just say that the president asks for an indulgence of 2 to 3 months. He doesn't ask for anything more. The fact that there's already been a delay of almost 4 years is not the doing of the president. It shouldn't be laid at his door, and he should not be made to pay the price for that delay. That delay has been unfortunate. A number of parties were to blame for it, but the president was not one of them. So it is unfair to burden the president because there has already been undue delay in this case. Going forward, your Lordship has expressed skepticism before about the finality that will be achieved on the judgment in September. Our point is that we can't predict what the future might bring, but what we can assure you is that this court will be in charge of whatever happens then. It will deny leave to appeal. It will deny a further suspension. So it will be in absolute control. And there is no fear that injustice might then be done when this court will be in full control of what happens. It is unfair with respect, effectively to deprive the president of his statutory protection only because one is understandably impatient that the process must make progress.
A skepticism on whether September would in fact resolve this matter is perhaps justified by how matters of this sort tend to snowball and continue forever, even with the best intentions of the parties. We know the stakes are so high, and that is why litigation takes the intensity that it does. So to say that there'll just be a short adjournment or for a couple of months, past experience doesn't bear that out.
With respect, my Lord, we're not saying trust the president, he won't take more time. We're saying this court will be in charge of whether there's a further delay. If the president is successful, the counterparties may appeal. If the president is unsuccessful, he may appeal. But whether there is then a delay as a result of those attempts is entirely in the court's hands.
So senior counsel Katz comes back after the reply without permission, I might add. However, he makes a point that is lethal.
There's something that's been bothering me. And there are two legs to what's been bothering me. One is that I half, and I emphasize half, forgot to make the points in my address yesterday. And the reason I say half was because Mr. Trengove said yesterday something which...
Are you seeking permission to address this?
Yes, I'm explaining why. Because it's really to help the court rather than anything else.
My Lord, I object to it. My learned friend has had ample opportunity. I was afforded the privilege of preparing my reply today. You can't just come with further points or new points. The debate is over.
The reason I ask is because I was expecting Mr. Trengove to deal with it today, and he didn't. And then it bothers me that the court is going to be confronted with something, and I'm going to suggest that anything that Mr. Trengove wants to say, pursuant to what I say, he can say today, he can say it in writing, but it's really to assist the court in what it's got to consider. That's why it's one narrow point.
I think we should if we will allow him to make a point.
It's a very simple point. Yesterday, Mr. Trengove said, before I argued about how our complaint on the papers that what's in the notice of motion isn't what he really wants. And I emphasized that in paragraph 1.2 of his notice of motion in this case, the President asks for an order which is not competent. And what he asks for in the notice of motion in paragraph, this is the key, pending the review, the important words are interdicted from what? From commencing the impeachment inquiry. And on the pleadings papers, from the Speaker's affidavit, it is clear that the impeachment inquiry has commenced. So he cannot get the relief to stop something that has already happened. So even were this court to consider granting an interdict, it can't be in the terms that the President has asked. And just to tie up the point, because Mr. Trengove said something yesterday about, well, if you look at the papers, you can see he's not actually asking for the commencement to be stopped, it's actually the witnesses. Well, I've given you the paragraphs.
Yes, yes.
If the impeachment inquiry, importantly, commences while the review application is pending, substantial portions of the inquiry will be completed before the review. Then, I just want to make the last point, just to tie up the pleadings point with what the facts are. The facts are, if one looks at the Speaker's affidavit, the Speaker's affidavit makes it clear the timeline as to what happened post 8 May 2026. And she makes it clear from her timeline that the commencement was sometime in May, the 20, whatever, either the 15th of May or 20th, sometime in May. And this application was launched on the 12th of June. So when this application was launched, the President must have known that he could not get the relief of no commencement. So the court cannot grant an order in respect of something that has already happened and to try to stop that. You cannot do that, as the court knows. I had given in my bundle of authority 2 cases to that effect, but it's a trite principle. You can't, once the horse has left the stable, you can't stop the horse from leaving the stable.
Wow, so when do we hear back from the judges?
On behalf of this court, we would like to thank counsel for the manner in which they addressed us. We will deliberate on this issue, and hopefully by the end of next week, we'll deliver judgment in this matter. Court will adjourn.
So by the end of next week, we'll know that they said no. Most probably. My biblical reaction. Therefore, submit yourselves to every ordinance, something ordained or institution of man for the Lord's sake, whether different kinds. I like institution here. One of the arguments that's been happening around this impeachment committee, a lot of people have been saying, yeah, but you don't want him to go because we'll have a worse president and now there's going to be a shakeup. You know, here's the thing, South Africa. What we will live with for the next 30, 40, 50 years is not President Ramaphosa, is not the president after him, or after, or after, or after. What we do have to live with are our institutions. And I think to a certain extent, now that the ANC has lost majority, many of us have still not plugged in that what's gotta hold this country up now are our institutions, because they will be here after the ANC has become a little rural party in a tent in Limpopo somewhere. We will still be left with our Chapter 9 institutions, which Ramaphosa is already hurting. We will be left with our South African Reserve Bank, which Ramaphosa is hurting. We will be left with our parliament, which Ramaphosa had injured. Thank God for the Constitutional Court that kind of saved it a little bit. But Parliament stole 3 years from us to know what happened in this case. We will be left with institutions. And here's the thing. Whenever we defend an individual at the expense of our institutions, we are really thinking very short term. But the thing is, every president comes in on top of institutions, comes in on top of precedents. We already have the precedents that sometimes the public protector looks into a narrow issue to protect a president, We have the SARB going after a narrow issue to protect the president. You'll see it in this video up here. And here's the thing. We would rather protect our institutions than any one man. Because you protect one man while your institutions fall apart, guess what happens? The one man leaves you and leaves you with no institutions. Does it mean everything's going to be hunky-dory? No, it's rough. But right now, we have to choose between Ramaphosa plus our fears or our institutions plus the future. And here's the thing, it's not cool. I'm not making light of what's uncertain. I'm not making light of an uncertain future. But let me tell you something, a country for me is its institutions. So let me hear what you think below. But no man can serve two masters, because either you love the one or hate the other, or you despise the one and honor the other. You can't serve God and Karl Marx. Let me hear your thoughts about the court case. I think there's no way he will win. Our courts have never really shocked me before. So if President Ramaphosa won this case, I would, for the first time, be shocked. So I'm not a betting man, but if I was, I'd be putting my money on the court staying in its lane. So let's make history together. Cheers.